Hey folks, James Abrenio here, owner of Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I want to talk about something that I get a lot of questions about. James, how do I give a deposition? How do depositions work? I'm scared as heck and I don't want to mess it up. So the purpose of this video is really to lay out a few tips that we use here at Abrenio Law that I use in my practice every day that I tell all my clients. So make sure if you find this video useful, make sure to share it with your friends and family. Go ahead and subscribe to us on Abrenio Law at our YouTube page where we're updating videos a lot. And with that, we'll get going. So also as a side note, you can see our information is right here on our slide. Here's the address, my phone number, and email address. So if you need to reach out, feel free to reach out. So number one rule when it comes to depositions, I want to be clear, don't stress out. Depositions can actually be a good thing. I always tell people, look, if you're in litigation in a car accident case particularly, but let's say it's another type of injury case, whether it's a slip and fall, med mal, products liability, dog bite case, any civil litigation, we actually want to look at as a deposition as a good thing. In many instances, a defense attorney, in order to actually get authority for settlement from their adjuster, from their insurance company, essentially their boss, they've got to essentially give enough information to let their people know, hey, this is a difficult case. So a lot of times they're going to use a deposition in order to essentially provide enough information to be able to get the authority they need. I always tell people a deposition is an opportunity to prove to that defense attorney that you're a great witness, that you're going to be able to articulate your position well, that you're compassionate, that you're empathetic, that people are going to relate to you. So depositions are the first time that any attorney on the other side really gets an opportunity to know you. Now, they may take the opportunity to try to mess with your head, try to be a little aggressive to you, but I always tell people, so long as you follow my rules and we're working together, you're going to be on the upward footing, and we'll talk about it in a bit, but keep your cool, we'll get through it. Now, the next thing is the truth will set you free. What I mean by this, usually my clients at Abrenio Law, when we bring people on, we bring them on because we believe in their story, we believe in them as individuals, and we believe they're telling us the truth, right? So if, assuming you're that situation, you're being represented by me, I always tell people, look, the truth in a civil case is going to set you free. What I mean by that is you don't have anything to hide. If you were legitimately injured because of somebody else's negligence and you're claiming legitimate damages, legitimate injuries, treatment, medical bills, lost wages, just tell the truth. There's not any real rocket science behind of it. You're just getting an opportunity to tell your story to a defense attorney. There's not a whole lot that, when you're telling the truth, that we have to worry about, to be honest. Worrying about being tricked into saying something that may hurt your case, all that stuff, to me and in my experience, we'll deal with it. I would rather you be focusing on being upfront and honest. That way you're not worried about the questions and whether or not you're being tricked and duped. Put all that aside, tell the truth, and we'll be just fine. Now, the other thing is rule number 2. Depositions are definitely different from trials, and a lot of times people are a bit confused by that. They see the movies, they see attorneys getting up and making grand open statements and objecting and yelling at each other. But in reality, depositions are very different. First of all, they can ask a lot more questions in a deposition than they would be able to do in a trial. And really, it's the concepts of discoverability versus admissibility. And what I mean by that, admissibility really gets to what can a jury hear at trial? What is admissible at trial? And at trial, there's something called rules of evidence. So for instance, hearsay, you hear that a lot. Hearsay is not admissible at trial. What is hearsay? It's an out-of-court statement stated in court for the truth of the matter. So for instance, witness Jenny gets up at trial and wants to say, hey, she heard John say that Greg ran the red light. Well, at trial, that's not admissible because that's hearsay. And unless the attorney is able to weave that into an exception to hearsay, which we're not going to get into those details, that statement's going to be thrown out. It's not going to be admitted at trial. Now, during a deposition, the question is something discoverable? Is that information discoverable? Now, the same witness testifying at deposition, Jenny wants to say that Greg said that Johnny ran the red light. That absolutely is a proper question, because the purpose of a deposition isn't just getting admissible evidence, it's allowing a party to investigate a claim. So in that situation, if Jenny says that Greg said something, that attorney may now then want to depose Greg or the ultimate person they said that made the statement, so that is discoverable. So there's going to be a lot of questions that are going to be asked that don't seem that aren't admissible, that may not even seem relevant. So for instance, a good example, a lot of times I'll have defense attorneys asking my client about where they went to college, high school, where they grew up at, and we're talking about a car accident in 2020. It's not really relevant, but my rule is, so long as we're not wasting a ton of time, I'm not giving a whole lot of headaches to questions that aren't really relevant. I'll let attorneys ask questions if it doesn't hurt us at the end of the day and we're not spending too much time. So don't worry about grandstanding, things like that during a deposition. Focus on your performance and I'll help guide you through that. The other thing is, at trial, I can do a lot more than I could do at a deposition, and this kind of relates to what we're talking about, discoverability versus admissibility, and the example I used about hearsay. At trial, if I hear hearsay coming in, I can say, Your Honor, objection, hearsay. The judge will say, absolutely right, move on, counsel. At a deposition, I really don't have a whole lot of objections to make. The first is objection to form, and what form is when essentially I restate it this way. I say, is the defense attorney asking an unfair question? Are they, like for instance, are they misstating what you said a moment ago? So let's say the defense attorney asks you, what color was the light when you drove through it? And you say, well, the light was green. And then the defense attorney follows up, well, when you just testified the light was red, what did you do next? Obviously, that's an unfair question because they misstated what you stated, and so that's not a proper question, and it essentially misstates what you're trying to testify to. That's kind of a simple example of what an objection to form is, but it's really objecting to the substance of the question being asked. It may very well be a discoverable area of information they can seek, but if they're asking inappropriate questions in an inappropriate way, then I can object to that. But again, I'm doing that sparingly only if it hurts us, because I don't want us to spend multiple hours in a deposition when it could be much quicker. And also strategically, it may benefit us later on. The other thing that I'm usually allowed to do that is kind of limited at deposition is objecting to attorney-client privilege information. So statements that my client and I had with each other, they can't say, hey, what did James tell you when you were prepping for this case? So those are going to be the two main objections that I, as your attorney, have at a deposition. Don't be freaked out by that. Again, we're talking about going back to the concept of discoverability versus admissibility, and ultimately the truth will set us free. They can ask questions that may be discoverable, maybe a bit intrusive and all that stuff, but so long as we're telling the truth, we don't have anything to hide, so don't stress out about it. And if they're asking unfair questions or privileged questions, I will be there to object. Another way that depositions are different from trials is it's usually a lot less formal. And depositions usually going to be held at a conference table, at a conference room, probably going to be at the defense insurance company's conference room. There's going to be a court reporter there, you, maybe a couple witnesses, and me and the defense attorney, maybe an attorney or two, but it's really a setting where it doesn't appear to be like a jury trial that you see on TV, or if you're going over in the courthouse here in Virginia in Fairfax, for instance, you go up in the circuit court, you're going to have bailiffs, you're going to have judges, you're going to have witness boxes and jury boxes, you're going to have formal objections and things like that. Now, to be clear, that doesn't mean that depositions aren't serious. That doesn't mean that we need to be very well prepared. What I'm saying is it should be a little bit less stiff. Now, of course, it's going to depend on the facts and circumstance of your case. Some cases are a lot more emotional than others. Some are a lot more straightforward. So, of course, if you have a complex case, an emotional case, well, we're going to be as formal as the facts require and call for. But most on par, when you're thinking about the difference between a trial versus a deposition, the trial is definitely going to be a lot more formal. And the other thing that I tell people is you can ask me, my client, can ask me a question so long as there's no question pending. What do I mean by that? So let's say the defense attorney says, Mr. Anderson, what color was the light when you were driving through it? If you have a question, you should go ahead and answer the question for the defense attorney, but if you have a question for me, answer it, and then you can ask me a question. You can say the light was green, and then you can look over at me and say, well, does he also mean this too? And we can have our little sidebar. But if we're following the technical rules, it shouldn't be the defense attorney asking you a question, you thinking of something and then leading over and asking me a question, because that's inappropriate, and that's against the rules of depositions here in Virginia, at least. Now, when we do have questions, we can always go out in the hallway and discuss them privately, all that stuff, but you can't ask questions so long as nothing is pending. The next rule number 3, listen to the question, answer the question. What do I mean by that? Take the time you need to understand the question. Again, and this actually applies at trial as well. If a defense attorney asks you a confusing question, you're not exactly sure what they're asking, take the time and say, well, I don't really understand what you're asking me. Can you restate it a different way? It's going to be better for everybody. It's going to definitely be better for you, because you don't want to answer a question you're confused by and then it be interpreted as the wrong thing that you're meaning to say. For the defense attorney, it's going to be better for them because they're going to have a clearer record rather than kind of rambling, non-responsive answers to a question that wasn't understood. So take the time to understand the question. If you need it repeated, just ask. We as attorneys, if we're good, we understand that sometimes our communication isn't clear, and we want to make sure that it is clear, and if it's not interpreted correctly by the person hearing the question, then we haven't done our jobs right. So we're not going to be offended. They shouldn't be offended. If they are, then that's on them, not you. And also, only answer the question that is asked. Perfect example. They ask you, Jane, what color was the light when you went through the intersection? Your answer should be green, red, or yellow. It shouldn't be, well, the light was green, it was raining, I heard a cat meow on the side of the street, and then there was somebody selling ice cream down the block. As you can see, the point is you don't need to volunteer information. You don't need to answer questions that don't really respond to questions that haven't been asked. That doesn't mean you have to be rigid and mechanical, and say yes, no, and be snippy about it, but just really focus on the question being asked, and there's no reason to volunteer information. And likely, if you're wanting to jump to the next answer, you're probably going to ask the question at some point anyway, but really listen and answer only the question being asked. Rule 4, and this is a really big one, don't be a jerk. What do I mean by that? Don't be rude. If the attorney on the other side is being rude, I'll deal with it. My job is counsel. Look, one of my earlier slides, I said there's very limited objections I can make. One of the things that I can do is advocate for you. I don't need to object to advocate for you. If an attorney is being rude, if they're yelling at you, I'm going to be straight up with the attorney and say, Mr. Smith, it's a fair question, but your tone is a bit aggressive. Can we calm it down because the tempers are getting raised? If the attorney continues, then I will continue too. If anybody has to be rude, that should be me, not you. That's my role as attorney in a deposition, is help control the communication, help control the situation. But if somebody's beating up on you unfairly, then I'm going to be there to advocate for you. Now, if they're asking tough questions, as sometimes it has to be done in a deposition, and they're fair questions, they're allowed to ask tough questions. And if they're being aggressive in the questioning, and let's say you're not responding, well, look, they have a job to do too. But objectively speaking, all things being equal, if they're just being rude, don't you be rude, and don't you definitely be rude is the starting point, because I'll have a talk with you. The other thing is, it's okay to say I don't know. Right? Somebody asks a question about an accident that happened 2 years ago, and you don't know exactly what what exact time of the day it was, or what you had for breakfast. It's okay to say I don't know. But on the other side of the coin, I don't want people to abuse the I don't know. I've deposed countless people where I'll ask a very simple question and they'll say, well, I don't know. I don't know. I don't know. And they think that they're being smart because by saying they don't know, they're not committing to something. Well, what they don't know is if I ask a question in a deposition and they say they don't know, but then they come to trial and all of a sudden their memory is clearer, Well, now I've got that prior deposition where I get to say, well, ma'am or sir, I deposed you a year ago and I asked you what color was the light and you said you don't know. Now a year later you're saying it's green with absolute certainty. What changed? And the jury's going to see that. They've changed their story. Number one, they've changed their story. Now they're lying to benefit them. Or number two, they were being a jerk before and trying to not volunteer information that was fairly asked. And the jury's not going to like that either. The same rules apply to you. If you're saying I don't know, number one, it's going to cause unnecessary tension in the deposition. It's going to make my job harder, but it's also going to bite you in the butt later on if you have to testify at trial. So again, the truth shall set you free. If you have a bad answer, meaning there's a bad fact in your case and you have to acknowledge it, look, it is what it is. No case is perfect. But I'd rather you tell the truth rather than lie to try to cover your case or say, I don't know. Saying I don't know when you know is also a lie too. So just to be clear about that. The other thing is look, be prepared for a deposition. It's not going to be a fun time. It's probably going to be several hours at least. For complicated injury cases, it may be the entire day, maybe in multiple days. They're going to ask a lot of questions. And this kind of goes back to don't being a jerk. If you're a jerk, or they're a jerk, or anybody's a jerk, it's going to make the day a lot longer. So just be prepared to be there for a while. Take a deep breath. Be as calm as possible. Be as relaxed as possible, because the less amped up we can be, the quicker it will be, the easier it will be, and ultimately you'll get through it. The other thing is rule number 5. Be honest with your attorney in deposition preparation. You need to be straight up with me. Of course, if I'm representing you, if Abrenio Law is representing you, we're going to know your case. That's our job, is to be prepared. But in order to know your case, a lot of times we're relying on information that you provided us directly. If you're not honest with us, a lot of times we're hamstrung. If there's a fact that I'm not aware of, and it's a bad fact particularly, I can't do anything to try to smooth over the rough situation. I can't do anything to anticipate it, and I'm going to be hamstrung. And also, we can't be proactive. It may be a bad fact, for instance, and this is really a trial as well, but a deposition it may very well apply to, that there's a fact that I know is going to come out in evidence. And if I know about it, I may want to proactively disclose it. That way, we're less likely to be punished by a jury because we're going after that. So, like, let's say, for instance, you're claiming a back injury, and 2 years before the accident, you had to get an MRI for your back. But since then, your back's been feeling great, and then now in this accident, you had a really bad back injury and it required surgery. Well, if you never told me about that prior MRI and that prior injury, I'm now no longer in a position to help you out when all of a sudden you see an MRI being put in your face because they got the record, and now you look like you were trying to hide it. That's bad at a deposition. It's even worse at trial. Whereas if I knew about that, there are cases all the time where I have clients with pre-existing issues that are doing okay, and then an accident exacerbated it, and then all of a sudden now they've got to get surgery, or they have serious pain, suffering, inconvenience, all that stuff. If I had known about it, I could have essentially affirmatively disclosed that, and then we could weave it into our narrative. And just so you know, under Virginia law, when we're talking about pre-existing conditions, the law says that you may have a pre-existing condition, but if your injury is exacerbated, they're liable for that. So if you didn't need surgery before the accident and you get in a rear accident, now you need surgery, well, they're liable for that surgery. But if you're not truthful with me, it's going to be more difficult for me to help you out. It's also going to be perceived as lying to the jury or to the attorney. And frankly, if you don't disclose it to me, I'm going to be thinking you're lying to me. I've had this happen before, and it's never good for anybody, and it ultimately hurts us all. Also, in line with that, if you are upfront about it, it may be something that you were worried about that's not a big deal, but if you hid it from me or tried to hide it from the circumstances, it's going to turn into a huge issue. So going back to the example where now you need surgery because of a back injury, but you had to get an MRI 2 years ago, a sprained back that then you went a year without treatment, you may be thinking, goodness gracious, that's a big deal, I may lose my case. But for me, it may not be a huge issue determined on the facts of the case. But if we're not upfront about it, all of a sudden it becomes a huge issue. So don't try to hide things because it may not be as bad as you think, and then I can't help you because I didn't know about it. Rule 6, your answer will always be best on the drive home. What I mean by this is, I get this as a trial attorney. I put on a good case, I argue what I'm going to argue, and then on the drive home, I'm thinking, goodness gracious, if I forgot to ask that question, I forgot to make that argument. That always happens. Every case I've ever dealt with, I've always thought I could have done something different. It's going to be the same with your deposition. You're always going to wish that you would have said something else when you go home and sleep at night and think about it. Nobody's ever given a perfect deposition. Just do your best. I will let you know if I'm representing you. I'll let you know if there's an issue right after the deposition if I know about it. Of course, sometimes we all miss things, but usually if there's an issue, I'm going to be upfront with you. It doesn't do me any service to lie to you or sugarcoat things if there's going to be a real trial issue because of something you testified to at deposition. So if I tell you, if I'm representing you in a deposition, I tell you, hey, we're all good. You did good. I didn't really see any issues. Do your best, separate yourself from it, and live your life. Also, you're going to have a chance to correct answers. After you give your deposition, the court reporter, the person's taking down the transcript, is going to ask you, do you want to have an opportunity to read and sign your transcript? And what that means is, if you agree to that, you're going to get a copy of the transcript and you're going to get a document that's called an errata sheet where you're going to be able to list on there, hey, on line 5, page 12, I messed up and I said this, it should have been that, or hey, you misinterpreted what I said, or there's a typo here. We're going to have a chance to correct your deposition. Now, of course, you can't change. You don't want to change the whole nature of what you've testified to, but for things that may have been misinterpreted, you can certainly correct those. Now, if it's significant enough, I could see a defense attorney wanting to redepose you, but look, if you need to correct it, you need to correct it, then that's certainly fine. So you'll get an opportunity. If you haven't seen a lot of depositions, go to YouTube. If you're watching this video, it's probably on YouTube. Maybe it's on the website, and we have a YouTube channel. The reason we do these videos is because we find YouTube is a very useful resource. The same thing with depositions. There's a bunch of them up there. Go up there, look at some depositions. You usually will find the bad ones that went wrong, but you also just find ones that from important cases. And I'm not asking you to memorize, but just kind of get yourself familiar, especially if you're nervous about how depositions are going to go. Now, if you have any other questions, here's my information. You can reach out to us at www.abreniolaw.com. There's my email, james@abreniolaw.com. Phone number. There's YouTube, Twitter, Facebook, all that stuff. So if you found this information useful, reach out to us. Also, make sure to subscribe to us on YouTube. It's #AbrenioLaw. You can find the YouTube channel and smash that subscribe button as you see on YouTube a lot. And also share the video. The technology is great now. I'm sure if you have questions, your friends, family, everybody on social media probably has similar questions, so make sure to share it. You can also find us on Twitter at abreniolaw.com. You can also find us on Facebook, again, at abreniolaw.com, where we try to do our best with keeping up with social media. Again, my name is James Abrenio, www.abreniolaw.com. It was a pleasure talking to you, and make sure to reach out. If you have questions, a lot of times I'll actually shoot videos based on questions, so put some comments in the comment section, send us an email with some questions, and we look forward to talking to you in the future. Thanks.